Hello and welcome to Life in Focus with me, your host, Stephen Akinsanya. And on this week's show, it's a real privilege because I'm going to be in discussion with not one, but two former Old Bailey judges, a place where I have practiced over the last 30 years or so, and had the pleasure of appearing in front of one of these judges in a murder trial as junior counsel. 2 years ago, I was moved to record a video. I was so incensed that young people appearing before adult courts up and down this country, charged with the most serious criminal offences, seemed not to understand what they were getting themselves into, the realities of being on trial at the Central Criminal Court, the reality of being on trial in an adult courtroom and all that comes with it, the fear, the unpreparedness for what is going to happen, almost a contest of men against boys, senior, experienced, clever lawyers who prosecute and being defended by equally able counsel, but the whole experience of being on trial, not only for the young defendant, but also for the victim's family watching the proceedings, and of course the family of those being charged. And I was keen to share this experience, and that attracted a huge number of views, and I was contacted by a number of families asking for help, and also a number of youth organizations and schools wanting me to share this really important message about the realities of knife crime and youth violence. And so it got me thinking about the dream of having a show where I could have two senior judges, retired judges who have tried cases, to share their experiences, answer some of the questions that the audience would want me to ask, and also to perhaps provide some insight into what it means to be on trial, what it means to sentence a young person, and also what some of the solutions could be. So on tonight's show, I'm joined by Bruce Houlder, King's Counsel. I could spend the whole show sharing the accomplishments of my two distinguished guests, but I'm going to summarize them in this way. Bruce Houlder has practiced criminal law for 51 years. He was appointed Queen's Counsel, as it was then, in 1994. He sat as a part-time Crown Court judge from 1986 to 2020. As one of the recorders approved to sit at the Central Criminal Court, which is the Old Bailey. He also was appointed as chairman of the Criminal Bar Association of England and Wales in 2001. In 2009, he was appointed by Her Majesty as the first director of service prosecutions. He's a bencher of the Honourable Society of Gray's Inn. He's a member of the Law and Criminology Advisory Panel for Sheffield Hallam University and is a doctor ex honoris causa of the university. Bruce is also the founder of Fighting Knife Crime London, and in the last few years he has made a particular study of the phenomenon of knife crime in the UK, and he now devotes his time to this work. Bruce, it's an absolute pleasure to have you on Life in Focus this evening.
Stephen, it's a pleasure to be here. Thank you.
My second guest is Nicholas Cooke, King's Counsel, called to the bar in the Middle Temple in 1977, practiced on the Wales and Chester circuit between 1978 and 2007. He is also was a senior circuit judge and recorder of Cardiff between 2007 and 2011, an additional judge at the Central Criminal Court, better known as the Old Bailey, between 2012 and 2018. And as a judge at the Old Bailey, he tried mainly gang-related murders, including shootings and stabbings. He was also a deputy High Court judge of the Queen's Bench Division in the Administrative Court and Planning Court between 2009 and 2018. He also was an additional judge of the Court of Appeal Criminal Division between 2007 and 2018. And as an additional judge of that court, he sat as a member of a 3 or 2 person court dealing with appeals against conviction and sentences from the Crown Court, and in cases up and including, in terms of seriousness, cases of murder. He's also a freeman of the City of London, and he enjoys the theatre and the music of Black America. I should also mention that he's currently pursuing a Doctor of Philosophy, and I'll ask him more about that. So good evening, Nick. It's an absolute pleasure for me to have both of you on this platform.
Good evening, Stephen. It's marvellous to be here. When I listen to all of that, I can scarcely believe it myself. So thanks very much.
Well, let's start off with a few easy questions, a bit like cross-examination when you start off with the easy things. Let me start with you, Nick, since you're live on the feed now. Why did you become a judge? I know my audience will be intrigued to know what it is that entices one to make that step from practice to becoming a judge.
I have to split it into two, in that I became a part-time judge first, as Bruce, of course, did, and long enough ago that the world is very different to now. So insofar as people have heard of the tap on the shoulder, I go back that far. It wasn't quite a tap on the shoulder, but I did a case in the Court of Appeal, and one member of the Court of Appeal that heard it asked me whether I sat, which is barrister code for "Are you a part-time judge?" to which I said no. And not long after that, I had a letter which began, "Your name has been mentioned," open brackets, "amongst many others," close brackets, "as someone who might be suitable, blah, blah, blah." And I replied saying, yes. Why did I do that? Well, in my naivety and comparative youth, because I wanted to make the world a better place. If that's not too pompous. Simple as that. Ambition was rather frowned on then. The world has changed. It was a hybrid at that time, because what happened after that, and I wrote back and said yes, was a long time past, about 12 months. And then I was summoned for a very cursory interview. So I sat as a part-time judge for a long time. Part two, which is a little bit more difficult. Why did I become a full-time judge? Well, I think that was quite complicated, because I was quite a successful silk doing predominantly civil work, despite what I ended up doing. So it wasn't, I'm afraid, because of the money, but it was, again, a sense of duty, and it was a complicating feature. It's not easy to talk about personal things. I think given what we're going to talk about might be helpful for me to mention it, that my late brother had in fact been lost his life as a result of a dangerous driver, someone who was convicted of dangerous driving. My parents were still alive. I'm not from a background where they really fully understood the law or those types of careers, and they were always very keen on me becoming a judge. They weren't really interested in the planning inquiries I did and things like that. They were interested in me becoming a judge. So when the chance came, I applied, and that was why, really. So a complication of world a better place and trying to please my parents. All right.
Thank you.
They're long gone, sadly, but
yes,
it's best to spell it out. That's the true answers. Thanks a lot.
Nick. Bruce, let me ask you the same question. Obviously, you're sitting as a part-time judge. Why did you decide to become a recorder? And perhaps you can also elaborate on some of the skills that are required to sit. You might have to go off mute there, Bruce.
I thought at the time it was very much a natural progression from being at the bar. As you have mentioned, I became a recorder in 1986. And I think, too, that I was one of those who didn't actually get a tap on the shoulder, but was asked to apply. And that's what I did. But I then got silk in 1994, and I was having quite a good time at the bar. And it had dawned on me, as no doubt it dawned upon a much more well-known QC of the day, Gilbert Gray QC, who I was doing a case with at the time. He said to me, just enjoy your time at silk. Don't be tempted by the bench, he said. Never be tempted by the bench. Maybe he guessed what I thought, that if I spent too much time every day sitting on the bench, I might become a rather impatient old judge in the end. And so he was probably giving me some very wise words. But sitting as a part-timer, I think I was able to make over a 34-year period, after all, quite a contribution and learn quite a lot from being a judge and from practice at the bar at the same time. One of the things you've got to do as a judge is to keep out of it. Some judges get, of course, appeal because they make too many interventions which shows some kind of bias. I feared that if I sat there too long on the bench, I might be one of those who showed my feelings by asking one question too many. Your job's to keep quiet. Your job's to make rulings on the law and sum the case up clearly and fairly in the end. So I think I made the best decision. I think, had a lot of fun in my career doing all these various things which you have summarized.
And just before I return to Nick, Bruce, could you just sort of share with the audience the type of cases that you would try as a recorder?
Yes, well, obviously when you start, you're given the lowest level of case, and as you progress and obtain what are called tickets to try more serious cases, for example, a serious sex ticket, you move to try rape trials and things of that kind. And you can't go to sit at the Old Bailey unless you've got one of those tickets. And I was fortunate, certainly in the last 3 years of my practicing career, to be able to sit at the Old Bailey, somewhere where I had spent so many years acting as an advocate for prosecution and defence. I regarded that as a very great privilege to be able to sit among some great judges and be in the place which I had come to feel was home in the end. So, yeah, that's where I ended up.
Thank you, Bruce. Now, Nick, I feel strange calling you Nick, because certainly the last time that I saw you, it was my lord. And I remember the case well. I won't go into the detail of it, but you were the presiding judge. And I think I can say this now, that I was fascinated as I listened to the legal arguments that were being advanced in that case, at the speed with which you grasped the arguments and the submissions and the intellect that was radiating from the bench. Now, obviously, as an Old Bailey judge, can you just share with me some of the types of cases that you would deal with? And is there any particular case that has stuck with you even into retirement?
Well, I'll answer the last part first and say so many cases have stuck with me into my retirement. I tried a great number. I think actually, including my time as Recorder of Cardiff when I had a murder ticket as well, it may well be over 100 murder trials. Certainly 100 murder defendants, because many of them were multi-handed. At the Bailey, predominantly gang murder. Peter Beaumont, the Recorder of London when I came, and therefore the boss, was under the, I think, misapprehension that my numeracy skills were a bit higher than they were. So I did get to do some of the small number of money cases, fraud cases, corruption cases, money laundering, but almost all the time I would try murders, and that tended to mean gang murders or murders that had some other complication. I tried one celebrated bodiless murder. They're quite rare and involve other issues. Because the domestic murders, the more commonly found forms of murder, are tried in the outer London Crown Courts predominantly and didn't come to the Bailey. They'd be multi-handers or have some other feature. I did some gross negligence manslaughter as well. Of course, they can be every bit as complicated as murder trials, and some high-profile sexual offending. The one that lives in my mind, widely reported as the Wolf of Wall Street case, which tended to make the front page of the Standard and so on. So some sex as well. And it is the Crown Court for the City of London. So every now and again, if you were filling in between cases, you'd have fights in Bishopsgate or shoplifting in Boots in Paternoster Square or that type of thing. But that was comparatively rare. So that's probably an outline. Many of the gang cases stick in my mind. To let you know, by way of example of how full on all of this was, The Guardian once ran a feature, and I didn't keep all the press cuttings, but that one I do have, because detailed account of one dreadful murder trial that I tried, and then in which there was plenty of meat for them to chew on, and then another one in which the paragraph starts off with Judge Nicholas Cooke QC, who was again presiding, and one in which there was an outbreak of violence in the dock, and I apparently said to the jury, and I must have because it was in the paper, I see this sort of thing quite often, which put into perspective what it was like.
Wow. Well, I recall the sentence hearing that I had to conduct in front of you, and what struck me was not only you performing your judicial role in passing sentence, but the sadness that you felt in having to pass such a long sentence on such a comparatively young man. And I know that this is one of the things that has concerned me in my own work, still in practice, that the age of the defendants appears to be younger and younger, and the frequency of young men appearing in the adult courts for serious violence just seems to be increasing. I know that recently there was a report, a Justice Committee report on the IPP sentence, which was abolished in 2012. And I am regularly approached by families who have young men still serving these sentences. And indeed, the Justice Committee described the IPP sentence as irredeemably flawed. And just so we can get this in some context, there are 2,926 people who are still imprisoned under the IPP sentence. 1,434 of them were recalled to custody. There are 608 in custody who, for over a decade, beyond their original tariff, and 188 of them were imprisoned for 2 years or less as the original offence. I mean, I was horrified when I read that, and I wanted to get both of your observations about the IPP sentence, even though it's been abolished. Let's start with you, Nick, and then I'll ask Bruce.
Yeah, I'll be brief and say, well, Lord Brown, the former Simon Brown, who we remember, described IPP as the single greatest stain on our criminal justice system, and I'd agree with him. So that's the verdict. I think another statistic that's worth adding is that there have been 74 suicides in prison by those subject to imprisonment for public protection.
Wow.
And you don't have to be a psychiatrist to work out that a contributing factor, at least maybe to that high suicide rate, the fact that they are serving a sentence without a closure to it. That must be a pretty dreadful thing. And I'm working at the moment with the two organizations of prisoners' families that are devoted to trying to get something done about this, who are UN GRIP or UNGRIP and the IPP Committee in Action.com. Some of the listeners might like to look at it. And they're trying to get somewhere with Parliament. But as my last sort of comment on all of that, the great difficulty is IPP is a product of the politicization of the sentencing system. And you can't dismantle it unless you depoliticize it. And to the constitutional lawyers, and there may be some listening, that's a serious problem because the executive and the legislature have occupied the territory of what used to be the independent judiciary. And it's very difficult for them without political costs to get out. Today, the new Prime Minister said that the Home Secretary, controversial appointment, not going into that, will be cracking down on criminals. I think I quote him verbatim or virtually verbatim. And if you take that sort of thing upon yourself, you can't really let the independent judiciary have full reign in dismantling something like IPP. So very difficult situation for everyone. But pressure needs to be applied because it's an injustice and it's having real consequences to families and defendants who've basically been disproportionately sentenced for the crime they committed.
Thank you, Nick. Bruce, I'm going to ask you for your observations.
Well, I couldn't agree more with Nick. There have been 1,670 recalls of people serving an IPP. That's recalled on license for breaking a term of their license. The parole board have to follow the rules so far as that's concerned. And they're now being recalled, I gather, at almost the same rate as they are being released. And I couldn't agree more with Nick when he talks about politics getting in the way. It's like the legislators swarming over the operating table, getting in the way of the consultant surgeon as he's trying to operate. It does not help. And indeed, there have been cries from politicians too that this should all end for now a considerable time. I mean, way back in 2011, before it was abolished, David Cameron, then the Prime Minister, called the IPP sentencing unclear, inconsistent, and uncertain. And after that, politician after politician, Ken Clarke, Michael Gove, called for reform of the system. The chairman of the parole board in November 2016 called for it to be reviewed. Her Majesty's Inspector of Prisons was doing the same. And all of them use similar language: flawed, decisive action needed, fairness and justice is required to relieve the pressure on prisons and to prevent the injustice of those sentenced without real hope of release. It's as bad and as serious as a life sentence, but for very often very low-level offending, such as assault occasioning actual bodily harm and so on. It really is a blot on our justice system. It's not the fault of the judges. It's the fault of the legislators who could do something about it immediately, and I hope Dominic Raab will.
Wow, thank you. Thank you so much for that, Bruce. And just for the viewers who are watching, I know Tunde asked the question, can someone tell me what IPP stands for? I'll ask you, Bruce, if you can, whilst you're live on
Yes.
the feed.
It's imprisonment for public protection.
Thank you.
If someone is assessed as being dangerous according to some very strict guidelines that have to be followed, then in certain circumstances a sentence of imprisonment for public protection had to be passed until it was all repealed in 2012. But that doesn't mean that those that got those sentences before 2012, in that window between 2005 and 2012, are not still in prison. So many of them are, and you quoted the statistics right at the start of this section.
Yes, thank you, Bruce. Now, another area of concern, and I'm, again, regularly approached by families who have a young man serving a very long sentence under the law of joint enterprise in murder cases. And they often talk about the unfairness of it. And I know that the Center for Crime and Justice Studies have looked at this along with other pressure groups since the decision in Jogi in 2016. And I understood when I did some research on this that there's not actually any data that's published on joint enterprise figures, something which the Center for Crime and Justice Studies criticize, and they say it should be remedied. But by their own analysis, and I'll just quote these figures before we get into the meat of the question, they analyzed all indictments and convictions of secondary suspects for murder or manslaughter, and it found that in the 3 years leading up to the Supreme Court ruling in Jogi, 522 individuals were charged as secondary suspects, whilst in the 3 years after, there were 547 charged. There was a similar pattern for homicide convictions of secondary suspects, with 296 from 2013 to 2014 and to 2015 and 16, and in 326 from 2016 to 17 and 2018 to 2019. Additionally, the number of Black people convicted of murder as secondary suspects rose from 45 to 83. That's 27% to 44% of secondary suspect convictions when comparing the relevant time periods before and after the judgment. So my question is, do you think that the joint enterprise law is fair in murder and offences of serious violence involving groups of young, predominantly men and from minority ethnic backgrounds? Who wants to have a go at that first? Nick, his hand's shot up. Bruce, if you could go on mute for me. Thank you.
I tried a lot of these cases.
You did.
I am not a politician. And so I'll give a one-word answer to the fundamental question, which is no, it is not fair. Of course, it's a combination of the substantive law and the very high starting points, in particular for murder. And we don't have time to discuss the sentence inflation, which, having such high sentencing starting points for murder, has caused to other offences such as manslaughter and causing grievous bodily harm with intent. I'm not for one moment suggesting that these offences are not extremely serious and that long sentences are unavoidable. But the 30 years starting point in the case of firearms, 25 years in relation to knives, they are very high. Because of pressures of time, I have to take this pretty quickly. Yes, it does bear down disproportionately and therefore indirectly discriminatorily upon Afro-Caribbean heritage, African heritage, Black persons in particular, because those gang cases exist involving those numbers of defendants. And obviously, the sentencing starting points don't distinguish secondary parties. So the judge is obliged to take that starting point. Since there might be a few people who are interested in history, as I am, in the audience, a little bit of historic, hardly trivia, because it was literally a matter of life and death, but which is worth noting, is that in the Homicide Act 1957, in which murder was classified as capital and non-capital, which forms a very close template to Schedule 21, the statutory provision which now governs murder sentencing. Capital punishment, liability potentially to the death sentence, was excluded for secondary parties. You had to have struck a blow or used actual violence. Didn't have to be the fatal violence, but you have to use actual violence upon the victim before you might be liable to be hanged. And in fact, those who didn't strike the fatal blow were usually reprieved anyway. So if you were one of these gang members that you now get falling foul of that, you were excluded. When they took the template and turned it into Schedule 21, there is no like provision. So judges have to take that starting point. And frankly, it's far too high for the hangers-on in gangs. I am not suggesting they could avoid a significant custodial sentence. I'm not, so to speak, soft on crime, but this mechanistic approach causes very considerable unfairness about which the judiciary are unable to act.
Thanks, Nick. Bruce, it was described by their lordships as the wrong turn in the law when Jogi, when the decision was announced in that case, but it did not lead to a series of appeals. And I only remember the case of Crilly being the only successful appeal, but I'm often asked why not? Why was there not a revisit of all these cases? Can you help?
Well, I think you have to go back a bit to remember what the situation was before, when the law of joint enterprises it tended to be called. I think it's better described as common purpose. But
yes,
what needed to be proved in the old days was what was called foresight of the possible outcome. And it was that foresight which led the individual to be guilty of, let's say, murder. Let's say it was an attack that ended in someone's death. Foresight of a possible outcome is not the same as an intention to commit the crime. So in Jogi, as you know, they changed all that. They got rid of what was called parasitic responsibility and replaced it with this much sterner test. But when I was defending these cases, I always found myself having to talk about how you prove intention. We all used to say you can never look inside a person's mind and discover what they're thinking. You have to look at all the surrounding circumstances. But it's still an elusive concept, isn't it? And it can lead to injustice. I mean, you're talking about sometimes some very feckless individuals who don't join one fact to another and reach a conclusion in their own mind, which you could describe as an intention. But nonetheless, their conduct and their behavior, their presence at the scene, and their general demeanor tends to indicate an intention, and it's left to a jury to decide. And I'm not suggesting that juries get it wrong. It's the best system that we have, but it's a hard call for them, isn't it, to decide what a person intends. But the injustice, the real injustice, starts at the sentencing stage, when the judge is left with no choice but to sentence in accordance with the guidelines, whether it's a primary or a secondary party. So your question is related to why no appeals. Well, we have trial by jury. It's the intention issue that is being decided. And provided there is some evidence upon which the jury could form that intention, it's going to be very difficult for the court to disagree with the verdict of the jury, who have simply found that here was a deliberate act of killing, and the defendant allied himself at least to the intention to cause really serious bodily harm, which resulted in death. If that's what the jury find, the Court of Appeal have their hands tied. There isn't a legal basis, unless the judge has misdirected the jury in some way, to get past that. But sometimes I think the argument is not sufficiently explained to those who criticize the law, call it joint enterprise, and
Yes,
because I was present, I've ended up with a life sentence. It's not quite as bad as that. What's wrong is the sentencing, in my view. It doesn't allow for the differences of circumstance, the difference of the individual standing before the court to be sentenced.
Thank you very much, Bruce. And following on, in fact, I'll carry on with you and I'll come back to Nick. There are a number of questions that I'm seeing here in the comments, and they're associated to my next question, which I addressed to both of you. Bruce, you first. Having tried young defendants for very serious offences, in your case, what have been your observations from the bench, not only of the young person, but also the families on both sides, you know, the victim's family and indeed the defendant's family? You have a bird's eye view sitting up there. What have been some of your observations over the many years that you sat?
Yes. Well, I would start by saying very much what you said right at the beginning, that these are people, perhaps many of them, who've never been into a courtroom, that are faced with people who lives have been different from theirs, very clever people very often, in an environment which is unnatural to them. And it's happening to them rather than them being able to control the process that then follows. Sorry, the number of the question was, can you remind me?
Yeah, effectively, what have been your observations from the bench?
Well, I gave some thought to that because I've just finished reading a wonderful book by an Old Bailey judge called Wendy Joseph, called Unlawful Killings. And she tells a number of fictional stories based upon fact, but fictional nonetheless, about murder trials that she has been involved in as a judge at the Old Bailey. And she addresses this question, and she looks down upon her court. She sees who is coming in to the court, the members of the family. She watches how they behave. She watches the accused, whose eyes dart up occasionally to the gallery. Sometimes there's nobody there for that young person in the dock, and that's the saddest moment of all.
Mm.
And there isn't a moment really until perhaps the defendant gets into the witness box and starts to reveal a bit about himself that you can really tell too much. You may have seen some reports in advance as the judge, and therefore you may have some insights, but you don't really know anything about that young man's background, what it is that led him into the dock at the Old Bailey, what the deprivation which he might have suffered, which might have caused him to be led into a gang or whatever it happened to be.
Mm.
So you guess to some extent, but you know there is a backstory. And at the end of the trial, you may not have got a great deal further in revealing that backstory because the affront has been put up by a defiant young man in the witness box who's not going to admit very much that he doesn't have to admit. He's not going to say anything about his family. He's not going to admit any of his weaknesses. And then it comes to the end, and he's convicted, if he is. You've got to sentence. And this, I think, is one of the things that led to me to do what I'm doing now. You never really get to the bottom of that question in a courtroom. So many of the people in prison are mentally disturbed in one way or another, to one degree or another. And at the trial process, at the sentencing stage, there isn't a great scope for dealing with people in that situation. There are not enough people to look after them in the community. There are not enough mental health care workers, or even professional doctors and consultants and hospitals that can care for these people. So they go to prison and join the rest of those young people there with the same kinds of problems. So judges have to rather turn away from that because the guidelines don't allow them much scope in going down that path. And so in the end, even probation reports are not full of the information that I remember once they were full of. Probation officers visiting the family, speaking to friends and colleagues, and filling a report with really personal information. These days, that information isn't really available. The probation service is overworked. They have to produce a risk assessment, which is to some extent formulaic, but it's also very useful. But it doesn't get behind the young man and tell the judge a great deal about them. So in the end, maybe I'm not as perceptive as Wendy Joseph clearly is in her book. I can't always read so clearly what I ought to be able to read as a judge about the young person that I'm sentencing. I have to find out what I can by asking questions, using my own judgment about it all. But in the end, I look around and say, well, what alternatives are there here? Has society provided sentencing alternatives for people like the young man before me? And too often you find not really, either because the sentencing alternative is not sufficiently supported by resources, or simply because there is nothing for the problems that that young man has, as opposed to the man you might try next. I say man, of course, I mean young woman as well.
Yes.
That's my view about that.
Thank you, Bruce. Nick, let me bring you back in. You know, I know that you've sat and tried many murder cases. You know, the bird's eye view from the bench, and then I'll ask you some of the questions that are showing up on my chat here. But
the bird's eye view, particularly with the young people, but perhaps more general than that, if we just focus on these gang murders.
Yes.
And perhaps preface it by saying one of the problems with all of this and the sentencing system is that it dehumanizes people. The impressions they create are as varied as the number of defendants that there are. They are all individual human beings, not monsters or demons or something like that. If I had a particular single word to sum up what the young ones look like, it would be dissociated. That they weren't really engaged in the process. I'll illustrate it by a little press report I looked up because it had stuck in my mind. It says 4 of the attackers were in custody within days and went on trial for murder at the Old Bailey at the start of the year. It's obviously before me. When all 4 were found guilty, one, I'll leave the name out, was clearly surprised. How can you find us all guilty? He shouted at the jury. Let me know, because tell me, bruv, the F you think you can. As he was led away, still screaming, etc., etc. He was obviously completely overwhelmed by the fact that he could be found guilty, because there was no eyewitness evidence, no forensic evidence of the type that blood had been found on his clothing or anything like that. What there was a network of highly complicated mobile phone evidence, vehicle registration, etc., etc., which was, in the eyes of the jury, utterly compelling, as it no doubt was. The code of silence had meant that he didn't go into the witness box. My memory is none of them did, which is quite common. And they have enormous faith in that code of silence and that no one will give direct evidence against them. Therefore, they won't be convicted. So the non-engagement aspect is quite striking in those cases. Yeah. Incidentally, taking a Bruce point up, if you do get reports and they engage in that, you often find something out, but nothing like as much as you would like. Although because of the impact of the starting points in murder cases, it can't really make any significant difference. So we're stuck with the fact that that's where we are. The privatization of the probation service, incidentally, was a disastrous step, and it couldn't really be rebuilt as satisfactorily as it had been for many, many years, which is a tragedy.
Yeah, thanks, Nick. I've got a couple of questions here. Rachel asks, how do you keep your emotions balanced when presiding over a horrific and traumatic case? It must be very hard to do.
It is indeed. The answer is only some people can do it, I think. I'm not claiming mystic powers, but yes, go and watch a football match, go and play sport, listen to music, go to the theatre. If you couldn't wash it out of your mind and go to sleep, you wouldn't last very long. But I don't think I was as good as some people at doing that, which is probably why I had had enough by the end. The more emotionally engaged you are, I think in some ways, not intending to blow my own trumpet, the more suitable a judge you are, but the more, once you are having to exercise or have responsibility without power, in other words, the more you're a prisoner of having to do something which you're unhappy with, the harder it is to do it. So I think many of the judges of my youth would not be able to cope with this because things like their faith or whatever it might be would stop them from imposing these sentences. And in my case, I was certainly finding it increasingly difficult that I was having to do things which in conscience I didn't think were the right way forward.
Just on that, Nick, can I ask the youngest person you had to sentence in a murder trial, what kind of tariff?
I had to look it up and did so. Rarely, because it was mostly males that I sentenced. It was a young woman, young girl. Again, case that made the papers. Some people will remember it. It was a girl of 15 who went, or she was 16 by the time I sentenced her, but only just 15 at the time of the murder, convicted by a jury of murder. She stabbed another girl. It's a sort of warning you give about this is very unpleasant when you describe the details. Through the temple, your bone is quite thin at the temple, with a pintail comb, which entered the victim's brain. Yeah, and victim of similar age who was in a coma, in fact, for 5 months before she died. So we talked about families and so on. It is difficult to imagine the sort of anguish of family and friends and so on when those are the circumstances. 12-year starting point under Schedule 21 because of her age. You couldn't prove an intent to kill against, I have to decide that, not the jury, as most will know, but not everyone in the audience. You don't have to prove an intent to kill to satisfy a jury of murder. Intent to do really serious injury will suffice. It would be a harsh finding to say that a 15-year-old would realize that if you attack someone with a comb, you would kill them necessarily. So benefit of the doubt to the defendant, but it was close. So a little bit of mitigation in that direction. Fought. Obviously a dreadful background, the person who committed the offence, goes without saying. So 12 years down to 10. So detention during Her Majesty's pleasure. That's a whistle-stop tour. The factors are more complex, but that gives you an idea of how you do it. So starting point of 12, convicted at the end of a trial, not sure beyond a reasonable doubt of an intent to kill because it's a furious reaction to something which is said. Territorial dispute between the girl hangers-on in a postcode gang would be the probable scenario behind that. But that's the youngest, and it's 12 down to 10. Incidentally, they're all going up. As of June the 22nd this year, all these starting points have been increased.
Yes.
And she was 16, so the starting point would be well above 12 now, so she would get a longer time.
Wow, thank you.
Do we want that? I mean, it's open to, we aren't consulted in a parliamentary democracy, but that's what's happened. They've all gone up.
Wow. Bruce, I'm asked also in the feed about emotional support for judges who are exposed to the evidence of many horrific crimes. Does such a thing exist?
Yes, I think it does. I practiced criminal law all my life and then went away to do something completely different, or more or less different, dealing with prosecutions coming out of the armed services, which on the whole didn't include murder, although on one occasion it did. But I look back during that time when I didn't have to go into court every day. There wasn't the same kind of pressure upon me at my life and what it had been, doing the job I had to do as a prosecutor and a defender, looking at most horrific photographs, hearing the most tragic tales, and looking at weeping witnesses and families across the court and having to speak to them before they gave evidence to reassure them about the system. And I got on with it. It was my day-to-day work. You had to put it behind you. You couldn't let that day's work affect the next case that you were doing tomorrow. Otherwise, you were letting somebody down and you weren't doing your job properly. But when you stop, you do have time to think. And I don't mean it literally, but I did get a form of post-traumatic stress. I looked back on what I'd done and I thought, this is just awful. And this is rather why I ended up doing what I'm doing now. I wanted to stop people entering the criminal justice system in the first place. It seemed to me that there was so much that could be done to stop young people joining gangs and ending up ruining their lives. Just about the last case I tried was a group of young people. I think there were 6 accused. Only one of them pleaded guilty. They were part of a gang that during the winter months lay in wait in 2 central London parks for commuters coming home in the dark. And they attacked them, they threatened them, they produced knives. 3 of those people were stabbed in the course of it. None of them, fortunately, died. But the violence they used was quite awful, kicking them while on the ground, defenseless people who were doing nothing but going home from work. And they fought it and they were all convicted. And how sad was that? Let me tell you this, all those young people knew each other because they were at college together. They didn't get to know each other on a housing estate round the corner in an alleyway. They got to know each other because they were at college. They had their life before them, but something got into them. The worst kind of peer pressure, the worst kind of character infected all of them. And they behaved quite abominably, not just once, but repeatedly. How does someone do that? I just don't know. So it seemed to me there was an awful lot of work to be done. And that's what I'm embarking on now.
Well, I'm going to ask you about that, Bruce, in a moment. I've got Marcia makes this statement, and I guess I know what the answer will be. She says groups of young men chopping up a person, killing them in horrific ways, they feel the person deserved to die. What is your view? How do you feel that act should be looked at? Victims need justice. And I think it's important that we remember, as much as we talk about justice and fairness for defendants, there are victims. Nick, and then I'll ask Bruce.
I obviously agree with that, although I'm bound to say that without criticising the entirely understandable reactions of victims' families, and I better interrupt to say they shouldn't be all identified with the same basket of feelings, because that would be wrong. Vengeance, wanting revenge against people who've done dreadful things, is entirely natural, but it doesn't bring closure. And it's one of the things that fuels sentence inflation. Our forefathers were content with life imprisonment to protect the public and much lower tariff figures. Once you start trying to equate the loss of a life with so many years, more and more years, it goes up and up. And of course, we have rather a strange system, and we don't have time to discuss it, but let me introduce concerns over femicide, the killing of women. Women are quite often strangled in the home or stabbed in the home. The starting point is 15 years. The gang knife cases in the street, the starting point is 25 years, the shootings 30. Isn't the difference too great? Don't we concentrate on the value of a human life too little, and the method of killing too much? So those things, I think, all need to be thought about beyond the simplistic, perhaps, world of that's a terrible crime, more time for that, please. It's a much more complex issue than that, simply that, well, because of concern about the victims, we've got to give more and more years. I haven't really got time to do it justice, but quite often the arguments for more and more years are linked to a perceived deterrent argument. Now, when they increased the starting point for knife crime from 15 years, knife murder, I mean, to 25 years, it was very much justified on the basis of deterrence. But there we do have the statistics. I won't recite them, but I've got them in front of me. There was no perceivable effect at all in deterrent terms by increasing the starting point. So it didn't save lives in the way in which it was advertised at the time. So I do think it's complex. I entirely understand, I've been there, why the natural feeling for victims is longer and longer sentences. But this is not justice purely on that basis, and it will simply go up and up, which is what's happening. And the politicians get a hold of it and they increase the sentences because that's where the popularity lies. And I understand it, but where will it all end? Will everyone get a whole life tariff?
Wow, well, there's a thought. Thank you. We have to have some real concern about that, and perhaps the new incumbent at the Home Office, but we'll see what happens. Bruce, you're retired now, and you perhaps look at it in a slightly different way, a non-judicial way, but what do you think of the causes of youth violence, and in particular knife crime? I know that you've got a new initiative called Fighting Knife Crime in London. You're going to tell me more about that, but what do you think of the causes of youth violence? Why are we seeing this escalation?
Well, I think we have been seeing it. We could have seen it coming for a very long time. I think for 20 years and possibly more, we have neglected our young people. And in recent years, services which have been made available to them, youth workers have declined, places for them to go have declined, and politics doesn't concentrate on them anymore. They are not considered the seed corn of our future. They are not considered the lives. They're not considered as the fathers and mothers of our future children, who need to be cared and nurtured and taught how civilized people must behave. But the reasons for this are much deeper. If you lay a map of knife offending across the country, there is almost a match between that and the most deprived areas of the country. And if you did the same thing 50 years ago, you produce practically the same result. And there's a third statistic that it's nearly all the same areas that were once deprived that are still deprived now. Those areas have been deprived of the help and assistance which they deserve. There are all sorts of reasons for knife offending. You can't take any single one of them to say that that is the reason. There's a very good book by a chap called Kiran Thapa, who talks about how it is important to address the child, to address that young person individually. There is no one reason why that young person might enter a gang, might carry a knife or commit a crime. It might be poverty, it might be marginalization of his ethnic group, it might be an adverse childhood experience at home, it might be some traumatic event that he's experienced, the fear of others, which causes him to carry a knife. It might be that he's being victimized or even worse still, exploited by somebody. All these are reasons why people get drawn in. And you've got to work one-to-one with these individuals to discover what it is in that person's case that has caused that person to commit an offence or to join a gang or to take some course of action which is damaging his or her life. But it is rooted in marginalisation. Disassociation was the word that Nick used. Alienation is another word. Alienation from the community, alienation from authority. All these things have a part to play. And each one of them is something we can do something about, it seems to me, if we care for our young people, pay more attention to them, and invest. I don't mean financially, because you don't need to spend money always, but invest in our young people much more powerfully and in a less short-term way than we do at the moment. There is no long-term thinking that goes into how we look after our young people. We throw money as sticking plaster at particular projects, of course, and we do that very well. And communities are brilliant at finding solutions, but it doesn't provide the long-term solutions. And that's what I worry about. The present government doesn't want to be a nanny state, but sometimes our young people do need a nanny state to provide the supporting mechanisms to help them live healthy lives away from the dangers that they face, the terrible dangers that they face as young people now.
Wow, thank you, Bruce. Bless you. Nick, following on from that, I'd be interested to get your thoughts on what rehabilitation looks like to you to ensure that young men and women who have been incarcerated can come out and add value to society. And also, is there any mileage in restorative justice?
Absolutely. There is some mileage in restorative justice. And those projects have been successful and are to be encouraged. I agree with everything Bruce said, and I would add a significant number of the children, as they were at that time, who I was subsequently to deal with as young adults in murder cases, had been in the care system. That's a sad indictment of the care system, because that's all our responsibility. Yeah. In relation to victims, and just returning to that in the context of rehabilitation, the cycle of offending leads to more victims. The best memorial to a victim is that we have reduced the number of victims in the future through our system. Then I can look the victims' families in the eye and say, we were people who tried to construct a system that would lead to less people being in your position. Not, we are politicians who exploited your grief to gather support for people who are not familiar with the nature of the people who commit offences, who are not familiar with the fact that we put people into prison where there aren't the schemes for them to undertake, etc., and they come out as bad or worse than they were. But those are the arguments that we have to try to muster to change tack. Otherwise, everyone will be having the same conversation in a decade's time. And I know there was a fashion for not paying attention to experts, but I think what we need in relation to rehabilitation, because I don't claim to have all of the answers, and sentencing generally, is we need the equivalent of a royal commission on sentencing, at least in relation to serious offending, and a broadly based royal commission which hears expert evidence on the way forward if we are to minimise these types of offences. And we're just not doing that. I mentioned that the starting points had gone up for young offenders in June. I wonder how many members of the public actually really knew that. The extent of the debate in Parliament was very small indeed. Nothing like what the debates were about the abolition of capital punishment, or even, and they were pretty limited about that, Schedule 21. Now there's no real interest, nodded through by the opposition. It's in the same bill that dealt with the greater criminalisation of protesters. Part one, because we're going to get a bit more of that, apparently. Yeah, that was what attracted all the news coverage, not increasing the starting points for 12-year-olds and upwards.
My goodness. Thank you, Nick. And I know that your doctorate, you're researching sentencing for homicide. And I know that there is perhaps a public outcry, which is pushed by the current government of there being changes to the sentences for murder with knives and firearms. And of course, the cry is, let's make the sentences more harsh. I mean, I think you said it before. Is it going to be a case where whole life terms will be given to everybody?
Well, research is a great thing, you see. If you were supposed to, and I did, start with an open mind, and I did not know what I would find in relation to the effect in 2010 of increasing the starting point for weapon to the scene cases. We all think of them as knives, but it's the difference between stabbing someone to death at home with your own knife and being out on the streets with a knife. And it's a big difference. And it went up from 15 years starting point to 25 years starting point for adults. They didn't interfere with young persons. That's been done in June. And now there's an increased starting point for young offenders with knife crime. However, the statistics are pretty clear on this. They have had no effect. The interest increase from 15 to 25 years had no effect. So if you want to justify it, you must justify it on retributive grounds, not deterrence. If you say, well, they deserve more, fair enough. But then you are saying that the man who stabs his wife in the house, or indeed the woman who stabs her husband in the house, more emotive subject because there are issues often of self-defense in the latter case, but not the former. The reality is you're saying that in some way, what makes such a huge difference is the setting, but not because we're going to deter knife crime. And that's a very odd way of looking at things, but it's extremely difficult. I think we've done it this evening, which is a tribute to the programme. It's very difficult to have those debates because it's so emotive. But we really should look at what would work. How could we reduce the levels of murders? Not something else. We're incidentally got a racial mix, but we're all men. If there was a woman who was keen on these things, they would say, and I'll pick a personal example. Well, when Mr. Cooke was prosecuting back in 2005, he prosecuted a man who strangled his wife to death in the home and a man who stabbed his wife to death in the home. And that's absolutely true. And they actually both got the same sentence, life imprisonment. We rather overlook that, incidentally. I take the view that it should be quite difficult for people who kill their partners or wives to get out because they're potentially dangerous to their partners and wives, which is the second part of the sentence. The tariff in those other things. they don't give the right weighting to the fact that in all of these cases, a human life has been lost. I'd find it easier to agree with a person who said it's 25 years across the board than a person who says this one's 15 and this one's 30. We've lost sight through the way these things have developed of the core harm, which is a human life is lost. And I think if we can get that over to the kids in the schools and to everyone else, the sanctity of human life is the determining thing, we might do a bit better in saving lives.
Thank you, Nick. We're in the final straight of the program. There's a couple of areas I still want to cover. Bruce, let me bring you in. Fighting Knife Crime for London, the initiative. Could you briefly just tell my audience what that is and what inspired you?
Yes. Well, I explained a bit about what inspired me. It was trying to keep people out of the criminal justice system who needlessly find themselves in the criminal justice system. And that got to me over time, and I felt I needed to do something about it. But I was no longer young. I couldn't become a youth leader and expect people to relate to me. So I thought, what can I do? I looked around, and indeed I wrote to the Deputy Mayor for Crime and Policing in London. I said, look, have you got a directory of all the organisations in London that are working to help young people? And I got a written reply back, which I still hold, which says, no, we don't possess such a thing. And that astonished me. So I set about producing something. There are, in fact, directories out there, but with one exception, they're not as full as mine. And certainly they don't cover the areas of interest that I now cover on my website. We're far more than a directory. We are a magazine which hosts serious articles about how we can help alienated young people and empower the next generation of young people from real leaders in the field, people who've been working with young people for very many years, working with youth violence on a one-to-one basis, who understand what they're talking about. And so that is a shop window for discussion and debate about how best we can deal with this, let's face it, appalling phenomenon of knife violence, which we experience in London. We also have a database, which, again, I couldn't find another organisation which had this, of most of the important reports that are produced by government, by charities, by NGOs, by London Violence Reduction Unit, by third sector organisations about children and about young people, about domestic violence, about street violence, and all the sorts of things that feed in to young people's experience of life. And the statistics and the solution and the research that is out there. We brought it all into one place, a very accessible library of serious documents that people have worked on for a very considerable time. And that's been a great use, I understand, to academic organizations, also to others working in this field. And people are starting to tell me about that. We're working now with the NHS Violence Reduction Unit. We're talking about a poster and leaflet campaign, signposting people to our website so that they can find pathways to help for the particular problem that they have. And their youth workers will have this information and be able to direct them in our direction. We use social media to draw attention to particular issues as they arise. And I always love it when I see Nick has liked one of our interjections on social media. But that is something we can do. We host videos that are relevant to young people. We host podcasts that are relevant, and a news area where people can post an upcoming event that might have to do with a particular community or a particular problem in an area. That is offered to youth organizations, it's offered to the police, it's offered to anyone who is working to help our young people in London. So that's the resource. And it launched last June. I remember that was a remarkable day because early in the morning I got a phone call from Downing Street. And I said, will you go into Downing Street to meet this special advisor to the Prime Minister? It was Boris. And it was a lovely day, June the 1st last year, and out we went into the garden, and all these hail bales were out there. Boris had got married a few days before, and it was all still there, the debris of that day. And we talked about it for about an hour and a half, and I heard nothing and wrote back a couple of months later and said, well, what was that for? Where do we go from here? And he said, well, I'm your line of communication if you need it. This is not a criticism, but that actually didn't lead anywhere. The letters that I wrote to government departments have not got very far, but that's not where I need to spread the word, it seems to me. I need to spread the word amongst those who care for young people in London, who are working directly with them. And if I can do that, then I think we will have achieved something. I work with a wonderful team of web designers who are absolutely committed to what we're doing. So that's great. And if anyone wants to donate some money to us to support those web designers, I'd be very grateful. Everybody who's doing this kind of work needs that support. There's a donate on the button on the website, www.fightingknifecrime.london.
Well said, Bruce. And I know that Rachel said she's already looked at your website. She says it's amazing. And thank you for all that you do. And she'll be in touch. Bless you, Bruce, for doing that. Also, everyone's asking for a part 2 of this discussion. They found it absolutely fascinating. Nick, let me just ask you, look, recently there was a report. The police have been called institutionally racist. Now there's a report saying the judiciary has issues with racism, being classed as being institutionally racist. I wanted to get your views on how we tackle racism amongst the judiciary following that report. And of course, do we need a more diverse judiciary?
We do need a more diverse judiciary. The report concerned, I haven't been able to read a copy, and I'm not I now cease to be the judge and answer the question in the way an academic would. I can't have 100% confidence in the research basis of the report because I haven't seen all the material. Yes. That's not me being mealy-mouthed, though. I'd be the first to say there is racism in the system. I'm not sure it's always helpful to use the hallowed phrase, in some ways, institutionally racist, because it tends to taint everybody with the same brush. And so it means that everyone who looks at a judge thinks that person's a racist. And that's not my experience. What is my experience is both unconscious and conscious racial bias is present and significantly present in the system. And it needs to be rooted out. Anyway, once someone has said this, there should be a comprehensive, independent inquiry into such allegations, because otherwise the taint remains, or the mud, if it is mud, sticks. And I would not be someone who would say that is not the case. There is something there, it's worth looking at, and it needs to be looked at comprehensively. Do we need a more diverse judiciary? We most certainly do. The government wouldn't thank me, but I'm not the government, am I? I'd spend money on a comprehensive inquiry into the performance of the Judicial Appointments Commission as well. And that has to be fully independent. I think I'm right in saying the present Lord Chief Justice was a former chair of the Judicial Appointments Commission. So that has to be done by an outside agency. Its problem, I can only look at this anecdotally, is like every other organisation, it's too prone to a people like us culture. And that means that, sorry, I'm just indicating to family that I'll be with them shortly. So just to finish that point, it's difficult to address a plethora of requirements that were real in creating a better judiciary. Gender, ethnicity, disability, and social background all at the same time. Experience in other jurisdictions shows us that when you try and address one, for example, gender, lapsing into the vernacular, you get a lot of posh women. If you try to address ethnicity, you can get atypical members of an ethnic minority. There are all sorts of problems. And who loses out? The formerly socially mobile candidates, because the judges' sons become the judges' sons and the judges' daughters. So I think it needs a complete, comprehensive, independent inquiry to restore public confidence and to mark out a way forward on what is an exceptionally difficult task. Nowadays, it's getting easier with gender because so many women choose it as a career, which is great. Yeah. And I'm not minimizing any of these needs, simply saying that if you're trying to ride 4 horses, it's extremely difficult. And it needs to be dealt with. And I don't think the JAC has done a very good job. That's pretty hard talk. Thank you.
Bruce, let's get your observations before we close out.
Well, that's a very full answer from Nick, and I haven't got any disagreement with it, but it is worth perhaps reminding ourselves that an estimated 78, I think it's a bit more than that, percent of the population in England and Wales identify as white British, and the rest are either black or coloured or some other definition. If you go to stop and searches in this country, you find that there were 7.5 stops and searches for every 1,000 white people, against 52.6 for every 1,000 black people. So it's no surprise that, first of all, we find a lot more young black people in custody, in our prisons. So it's no good saying, well, we've got to mirror among the judiciary the same balance as society has. Really, perhaps we need rather more of a balance towards what are called the ethnic minorities. I know that one's perhaps not allowed to use the expression minorities, and I agree with that argument, but you know what I mean. We need to have more people from different ethnic backgrounds in our judiciary, far more than the balance in the general population. And a lot more work needs to be done into that, and that can be part of the study that Nick suggests, the commission that looks at that and looks at the kind of measures that will be needed to create real balance in our society. These are difficult questions for judges, and we must face up to the criticisms that are there. But I too am one that would prefer to understand the depth of the research that has led to this recent report. I couldn't find it. I found David Lammy's report in 2017, and I read that. And one can see the people that helped him there, and there's a lot to learn from that. Very little has been put into effect, it seems to me, as far as the judiciary are concerned, and more work needs to be done on that, and more specific research needs to be done to answer that criticism, because it's not an acceptable criticism. Judiciary can't exist if that is the criticism that is made of them, and retain the dignity that the profession and the justice system deserves.
Thank you, Bruce. We've reached the end. It's been fascinating, scintillating. It's been honest, it's been open, it's been truthful. And I know those watching have been so grateful. There are many, many comments asking for a part 2. I shall start working on that. And it's been an absolute honor to have both of you join me on Life in Focus. Before we go, though, I do want to get your closing thoughts, both of you, on this issue of knife crime. And then I'll close with a couple of closing remarks. Nick, perhaps you could go first.
The status quo is not acceptable. So we have to address this. And the toll in loss of life is too great. The damage to societies is too great. we have to deal with it. I didn't get the chance to say, but I think it is important that we have to be careful that discussing knife crime doesn't become a racial construct. That a lot of people are killed with knives in a white on white setting. A lot of women are stabbed to death. So we need to address it without simply thinking of this gang culture, which is a serious problem in its own right. But we do have to remember that this is all part of there's a lethal weapon which we can all get quite easily situation. And I think we can lose sight of that. It's been a marvelous discussion, I think. I've been as frank as I possibly can. I ought to stress these are my views alone, aren't they? I don't represent anybody else, and I'm no longer a serving judge, and I've been able to be forthright because of that. But we need a forthright approach to these things. Longer sentences is simply not the answer. It won't save lives. And what we should dedicate ourselves to is saving lives. That means understanding why the offences occur and dealing with the causes, and not simply thinking that if you add another 5 years, there'll be a reduction, because there won't.
Thank you, Nick.
Thanks
Bruce, your closing thoughts?
Well, I've been giving some thought recently to this, and I've started to draft a paper in relation to it. Where it'll go and where it'll end up, I have no idea. But it has in mind a national plan to solve this problem of youth alienation, and obviously the violent consequences of that, and the consequences to our society generally. And the purpose of such a national plan would not be to produce another report, because I think most of us are fed up with reports that gather dust. But it would be a plan, a national plan, which would be the product of a statute itself, and it would impose an obligation on government to require early legislation upon the results of that plan. The plan should be put together by people who would work for nothing. And there are many people in the society that would form part of that panel who would work for nothing, from business, from financial and social mobility organizations, and knowledge leaders in social action businesses, in youth engagement, health, mental health, criminologists, clinical psychologists. These people together can work out a plan as to how to address the consequences of years of failure. And part of that plan should be to decide how it can be done with the minimum resources, using the goodwill of people, which is out there, to solve these problems, to use education, to use social mobility, to use businesses with no extra cost to the state, at least minimal extra cost. And part of the product of this plan would be to set up a legal responsibility on the state to bring before Parliament for approval the practical solutions that would emerge from such a panel. An obligation of that body would be to provide some measure of the potential cost savings to society generally. This is the savings to police, the savings to criminal justice, the savings to health, the savings to the general well-being and happiness of our nation. All this is a return of value. And how much would be saved if we had these measures put into place in the long term, not just money being passed out in the short term? That's necessary. But long-term thinking is required, and there should be a committee of the House to make sure that the purpose of the legislation is carried through. The preamble of my bill would underline a national obligation that we have for our young, and the duty of the state to achieve the most cost-effective way to drive forward the recommendations of that panel. Now, with that argument, it shouldn't be a party political dispute about it, should there? It's what everybody wants. It's saving money, and it's achieving the best for our country and the best for our young people. So something of that kind is what I would suggest.
Wow. Thank you. Thank you so much. And I hope the powers that be are watching or will be alerted to this fascinating discussion. Bruce Houlder, King's Counsel, Nick Cooke, King's Counsel. I want to thank both of you. It's been an absolute pleasure and honor to have you on this platform. And I know, looking at the chat here, that people are crying out for a part 2. There will be a part 2 when we can revisit this issue, particularly in light of the sentencing increase. But for now, I want to thank both of you for your time and for joining me and giving an enlightening overview of your time sitting as a judge, both of you, and your insight into knife crime and how we might tackle this real problem in our society. Thank you both, gentlemen. I just want to close out with this. It was alluded to in the discussion about investing in people. We have a real problem in our nation right now with youth violence and knife crime. Saving lives, understanding why, dealing with the causes. We don't do that by just racking up the years, increasing sentences. That's not the answer. And we only need to look across the pond where ridiculous sentences of 140 years plus are given out to defendants, but yet youth violence and violence generally is rife in that country. So let's think about what we're doing. Let's think about proper investment, not short-term measures, not sticking plasters, but something that Bruce said. We look at the most deprived areas. Let's invest in those areas. Let's invest in the people who know what they're doing, who are engaged with these young people, to stop them appearing before the criminal courts up and down this land, where barristers like me are tasked with defending them, and judges such as Nick and Bruce are tasked with trying these cases, because it has an impact on all of us. It's all our problem. It's not just one particular section of society. So let's do what we can. I look forward to inviting these two wonderful guests back on this platform where we can continue this discussion, because perhaps someone will be listening and someone will take that listening and put it into action. But for now, I want to thank you for watching Life in Focus. I'm your host, Stephen Akinsanya, a barrister at 15 New Bridge Street Chambers in London. I'll see you next time. God bless.